Today in the Indicator HR and Employment Law podcast, we're discussing the judgment in the case of Cancanala Pali and Loesha Energy Systems Limited, in which the Employment Appeal Tribunal was asked to consider whether an employer acted in breach of contract by withdrawing a conditional job offer. In this case, Kay successfully applied for a project manager role. The employer sent Kay an offer letter by email, which said the offer was subject to receipt of satisfactory references, a right to work check, and a successful 6-month probation period. The employer proposed a start date of the 1st of November 2022. On the 26th of September 2022, Kay emailed to confirm, "I accept the offer," and promised to sign and return the documents in a few days. Over the next 10 days, Kay returned the requested forms and provided copies of documents confirming his right to work in the UK. On the 7th of October, the employer sought to delay Kay's start date by 2 months, to the 3rd of January 2023. Kay replied to say that he had already booked flights to the UK for himself and his wife, and sought clarification of what pay he would receive for November and December 2022. On the 11th of October, the employer emailed Kay saying it was no longer able to offer him the contract for the position of project manager commencing on the 1st of November. Kay subsequently brought a breach of contract claim on the basis that the job offer was withdrawn without appropriate notice. The Employment Tribunal dismissed Kay's claim, holding that although the job offer had been accepted by Kay's email on the 26th of September, this was subject to 2 conditions, the receipt of satisfactory references and a right to work check, and neither of those conditions had been satisfied. In the alternative, if the tribunal had found there to be a binding contract, it concluded that there was an implied term that, as Kay had less than 1 month's service, the employer would not be required to give any notice, and they had in fact given him a week's notice. The Employment Appeal Tribunal upheld Kay's appeal and held that the tribunal had erred because it had not considered, or if it had considered, did not explain why it had discounted, Kay's submissions that A. The job offer conditions were conditions subsequent, i.e. conditions that terminate or excuse an obligation such as a contract or part of it, and not conditions precedent, i.e. conditions that trigger or activate an obligation such as a contract or part of it. And or B. The conditions of the job offer imposed a degree of obligation on both parties such that the employer did not have an unrestricted right to withdraw from it. Further, the tribunal had erred in its conclusion that there was no implied term as to notice. The Employment Appeal Tribunal set aside the tribunal's decision and concluded that the contractual conditions were, on the facts as found by the tribunal, conditions subsequent. Further, the Employment Appeal Tribunal implied a term for reasonable notice, which in this case would have been 3 months' notice, and held that the employer was in breach of contract by terminating Kay's contract without reasonable notice. This case is a reminder that a withdrawn job offer can sometimes amount to a breach of contract. Employers should carefully construct any conditional job offer to clarify the circumstances under which it may be withdrawn. It is also perhaps notable that the employer's reason for withdrawing Kay's job offer did not in any way relate to Kay's failure to meet the terms of his conditional job offer, but rather related to its own completely unrelated reasons. Look out for further episodes in this series to stay up to date on all things HR and employment law related.